Trump administration prevented from reducing funding due to sanctuary policies. What occurred? On August 23, 2025, U.S. District Judge William Orrick, appointed by Obama, issued a ruling that extends a preliminary injunction, which bars the Trump administration from withholding or imposing conditions on federal funds for at least 34 cities and counties because of their sanctuary policies. This revised order builds upon an earlier injunction from April that initially safeguarded around 16 jurisdictions, including San Francisco, Portland, and Seattle. The updated list now encompasses several significant U.S. cities such as Los Angeles, Boston, Denver, Baltimore, Chicago, and Columbus, Ohio. Judge Orrick concluded that the administration's executive orders and policy initiatives, directing Attorney General Pam Bondi and DHS Secretary Kristi Noem to withhold funding from sanctuary jurisdictions unless they adhered to federal immigration enforcement, represented an unconstitutional, coercive threat. He stressed that such measures surpassed executive authority regarding federal spending. The administration has already filed an appeal against the previous ruling. Wider legal conflicts. Simultaneously, a coalition of 20 states led by Democrats and the District of Columbia initiated lawsuits against the Trump administration, contesting its decision to condition over $1 billion in crime victim grants under the Victims of Crime Act, VOCA, on compliance with immigration enforcement. The plaintiffs contend that these conditions violate Congress's authority over federal spending and threaten essential services, such as emergency housing, counseling, and court transportation, for crime victims. Moreover, another federal judge has prohibited the administration from mandating certain states to enforce immigration policies as a prerequisite for receiving transportation grants. Why it matters. 1. Oversight of executive authority. These decisions highlight the constitutional tenet that the federal government is prohibited from using financial incentives to force policy alterations by local or state governments, a significant concern under the Spending Clause and the 10th Amendment. 2. Safeguarding critical funding. Local governments and states contend that millions, or even billions, of dollars in funding are essential for crucial services. The loss of VOCA grants, for instance, could severely undermine emergency services for at-risk populations. 3. Federalism and local independence. Sanctuary policies are designed to enhance community trust and public safety by restricting local collaboration with immigration enforcement. Legal precedents confirm that local entities cannot be mandated to implement federal immigration statutes. What lies ahead? The Trump administration is contesting Judge Orrick's broadened injunction. The lawsuit regarding VOCA funding and associated challenges concerning executive overreach continue to advance through the judicial system. These ongoing legal disputes are poised to shape the limits of executive power regarding funding and federalism for the foreseeable future. Funding reductions for sanctuary cities/counties, 34 jurisdictions. Injunction prolonged by Judge Orrick. Prevents coercive threats to withdraw funding. VOCA crime victim grants linked to immigration. Lawsuit initiated by 20 states plus D.C. Questions the overreach in associating aid with policy adherence. Conditionality of transportation funding. Another injunction halting it, June 2025. Affirms that Congress governs spending stipulations. This series of rulings reinforces judicial protections against governmental overreach and emphasizes the necessity of a distinct separation of powers concerning federal influence over local authorities.